So an important case is seeking Supreme Court review. This case involves whether firearms magazines are firearms parts protected under the PLCAA and whether companies that make them and sell magazines can be sued because of third-party criminal conduct. So let's talk about this. But real quick before we jump into this video, if you think it's time for the Supreme Court to take up more two-way cases, go ahead and hit that like button and subscribe. Also want to give a shout out to one of the main supporters of this channel, which is USCCA. Through your membership, you get training, education, and self-defense liability protection. So if you carry a firearm, I highly recommend you take a look into USCCA, and I will leave a link to them down below if you're interested. As I mentioned in the intro, in this video, we will be breaking down an interesting Second Amendment case which is currently seeking Supreme Court review. The case is KCI versus the 8th Judicial District Court for the state of Nevada. In this case, a manufacturer of firearms magazines was sued because of one of their magazines being used by a criminal. This whole case revolves around the PLCAA and whether or not KCI as a company, a firearms company, can be held liable for third-party criminal conduct. This case, of course, could be critical to protecting all firearms companies from frivolous lawsuits that the current agenda of the Biden administration is essentially trying to put in place to weaken the PLCAA's protections. Now, the facts which led to this case are actually interesting. KCI is a company that manufactures, imports, and distributes magazines, and it's a wholesaler of magazines. One of KCI's magazines was used in the furtherance of a shooting that occurred on August 4th, 2019. The individual had obtained the magazine via a second individual who had purchased that magazine from a federally licensed retailer, and it wasn't KCI. So you had one individual purchasing a firearm and magazines, and then essentially, I guess, sold them or gave them to this other individual. That original individual who gave the magazine to the shooter has himself been criminally convicted of possession of a firearm by an unlawful user and making a false statement regarding firearms. Now, the family of the victims then filed a suit against KCI based upon its allegedly negligent manufacture of the magazine. KCI subsequently moved to dismiss the lawsuit on the basis that its magazine is a component part of a firearm and therefore entitled to protections and immunities under the Protection of Lawful Commerce in Arms Act, also known as the PLCAA, which is a federal law. Now, on review, the court ultimately found that KCI's magazine was not a component part and therefore was not protected immunity and protections under the PLCAA. Therefore, the court denied KCI's motion to dismiss the case. KCI, in response, then filed a writ of mandamus up to the Nevada Supreme Court, alleging that the lower court clearly committed an error by denying the motion because of a firearm magazine not being a component part of a firearm, which should have afforded it if it, should be actually a component part of a firearm. A magazine clearly is a component part of a firearm, should have been afforded protections, but here you had this lower court saying no, it's not. However, on review, the Nevada Supreme Court denied KCI's petition for a writ of mandamus. That has now led ultimately to KCI having to file a writ of cert up to the Supreme Court of the United States seeking relief from the Supreme Court. The question presented to the Supreme Court of the United States is simply whether a magazine is a component part of a firearm under the Protection of Lawful Commerce in Arms Act. Now, you may be asking yourself, well, I don't know what the PLCAA is. What is that? What does it mean? The PLCAA is a U.S. federal law that protects firearms manufacturers and dealers from being held liable when crimes have been committed with their products. The PLCAA is a law that is supposed to prevent a person from suing a gun manufacturer or a gun dealer because a third-party individual takes a gun, takes a firearm, takes a component part, and commits a crime with it. This means that the PLCAA is intended to provide protection not just for firearms and ammunition, but also parts as well. However, in this lawsuit, the lower courts found that the case should not be dismissed because of the PLCAA, since they believed a firearm magazine is not a component part afforded protections from this lawsuit. So the two main reasons that the lower court found that this rifle magazine in question is not a component part under the PLCAA is because they said that the rifle could still fire one shot without the magazine, and also because the magazine was not purchased or sold with the rifle that was used during that incident. Now, based on that, you can see how twisted the logic is where the courts ultimately decided to let this case move forward when it should have been dismissed under the PLCAA. In their petition, KCI goes on to point out that in this particular case, the lower court correctly cited to a prior District of Nevada opinion holding that a bump stock was a component part of a firearm under the PLCAA. Here, KCI is pointing to prior precedent in Nevada where the courts have found that a bump stock is an essential component of a firearm, even though you don't have to have a bump stock on a traditional rifle. You can just have a traditional stock on a rifle, but you have precedent in this jurisdiction that says that they consider a bump stock an essential component. And so the plaintiffs here, the petitioners here, KCI, are saying, how could there be precedent that says a bump stock is an essential component, but not a magazine? KCI is pointing out that the logic used by the Nevada Supreme Court and the lower court would ultimately mean that a lot of parts of various rifles and various handguns and other firearms would not be essential components, because you don't need a bunch of parts, you don't need optics, you don't need sights, you don't need magazines is what they're arguing, pistol grips, buffer tube, a lot of things you don't necessarily need to fire a single round of a firearm or a handgun, a rifle or whatever. So the logic being used by these lower courts would mean that it would open the door to a bunch of litigation despite what the PLCAA says. KCI in their petition to the Supreme Court says that, as this court knows, there have been repeated longstanding calls for Congress to enact legislative change to address numerous issues related to firearms. However, Congress has largely declined to enact sweeping legislative change with respect to firearms or large capacity magazines. This lack of action has prompted interested parties to resort to using the judicial branch of the government to realize their legislative goals. Nonetheless, allowing this type of litigation to persist violates Congress's intent in enacting the PLCAA. Indeed, Congress explicitly determined that imposing liability on an entire industry for harm that is solely caused by others is an abuse of the legal system. The blanket immunity offered by the PLCAA exists for situations such as the case at bar, in which a maverick judicial officer would expand civil liability in a manner never contemplated by the framers of the Constitution. Based on that, KCI argues that the Supreme Court must intervene in this case and must ultimately rule in their favor. KCI argues that even though this case is at an interlocutory posture, to permit the lower court to proceed forward with the case at hand would undermine the very purpose of the PLCAA. They state that KCI should in no way be required to wait for the district court to first resolve outstanding factual issues. Immunity from suit exists precisely so that parties do not have to subject themselves to discovery and lengthy trials. And that, in my opinion, is very true. The whole purpose of the PLCAA is to prevent these types of lawsuits from ever being brought. It is meant to dismiss these cases before they go to a full trial or discovery or facts or whatever. It is meant to dismiss these cases, which is the very thing that the lower court denied. But that's ultimately what the anti-gunners want. They want to be able to bring these lawsuits despite the PLCAA. They want to make the PLCAA toothless. They want to drag smaller companies, larger companies into multi-year, multi-million-dollar litigation to ultimately drain their funds and sue them out of existence. Now, ultimately, we will see if the Supreme Court wants to grant review of this case. Currently, this case is set to be distributed for conference before the Supreme Court on September 26th. I believe that's one of the first weeks that the Supreme Court will hold conferences once they come back during their next term. Now, traditionally, the Supreme Court does not grant review of cases that are at an interlocutory posture like this one, but this case could be interesting enough and could be important enough because of how it's letting these types of lawsuits proceed forward, which the PLCAA is meant to prevent. So the dismissal should have taken place. Now, ultimately, the Supreme Court is very unpredictable. They have a lot of cases presented to them, and they only take a small percentage of all these cases up for review. But if we get any more information, I will let you all know. Also, if you like this video and you'd like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, and it signals to YouTube that you guys see value in these videos and in this type of 2A news. As always, I want to thank everybody who likes, comments, subscribes, who hits the notification bell, who shares these videos. You guys are directly impacting these videos, impacting this channel, and helping me to reach and educate more people than I could ever do on my own. So as always, thank you all for watching. Don't forget to like and subscribe. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.